Okay, I'll go ahead and call to order this hearing of November 14th, 2024 for case file Z0075-24. My name is Joe Turner. I'm the county hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing today. I start by saying I'm not a county employee. I am licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting a somewhat independent review of the application before me today. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Board of Commissioners and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker, and I believe I am unbiased with regard to this application. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another. And they can do that when it's your opportunity to testify. This is an appeal of a planning director's decision. I'm required to conduct a de novo hearing regarding the appeal, which means the applicant continues to bear the burden of proof on all issues, and I'm not allowed to give any weight to the planning director's prior decision. I have to make an entirely new decision based on the applicable approval criteria. But the procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are available on the county's website. Then the applicant will have an opportunity to present their proposal and appeal and ask any relevant questions of staff. Then if I don't see anybody else, but if anybody else appears and wants to testify, oh, there, one attendee. Anyway, if anybody else wants to say anything about this application, they may do so, whether in support, in opposition, or with questions or concerns. Once everyone has had an initial opportunity to testify, I will give staff and the applicant the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Anyone with interest in this application may offer relevant oral or written testimony, but testimony should be relevant to the applicable approval criteria, which are set out in the staff report. However, it's also important that you make your best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that everyone can understand what it is. If the applicant wants to object to any conditions of approval on constitutional grounds, they must raise those objections before me as well. If anyone feels they need more time to prepare, they can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have the opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we'll come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody wants me to hold the record open for any other purpose or to continue the hearing, they must make that request before the close of the hearing today. Also, my decision must comply with state law that requires that I issue a final written decision within 120 days after this application was filed. So there's some limit to how long I can continue the hearing or hold the record open. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. There's no arbitrary limit to the length of time you can testify, but testimony should be relevant to the applicable approval criteria. Also, please don't repeat testimony offered by yourself or earlier witnesses. But that concludes my introduction. Staff will summarize the Zoom process, technical issues of how people can indicate that they'd like to testify, etc. Mr. Forcell.
Thank you, Mr. Hearings Officer. My name is Eric Forcell. I work with Clackamas County Planning Department. I'm a land use planner there. I'm going to read some information about this process. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make this clear when that is. If you want to provide additional testimony or new testimony, utilize the raise hand feature. For attendees using a computer or iPad, you have a raise hand button on the Zoom bar on the top or bottom, depending on which device you're using. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it's time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email written testimony to me, e4cell@clackamas.us, and I will have that visually presented for you shortly. Or mail it to the Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, 97045. My contact email is also available on the web page where you found the Zoom link today for today's hearing, and testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address. And you need to do that by emailing me, the staff contact for the application, or by entering it today in the Zoom chat function during the hearing. That's it for the housekeeping components. I can pass it back to the hearings officer.
If you want to go ahead and summarize your, if you have any response to this, the appeal or otherwise we can go directly to the applicant appellant.
Oh yeah, I can summarize my presentation now. Just give me a second to share my screen here. Can we see that?
Yep.
Okay. So as mentioned previously, this file is Z0075-24, and it is a modification of a previously approved design review. This is my contact information and my email address, my desk phone, our physical address, and our office hours if you want to visit in person. The overview of this application: the applicant is appealing a denial of a design review modification to a previously approved design review approval, County File Z0096-02D. Specifically, the applicant is requesting to place a storage container in the location of an existing loading dock berth. Z0096-02D approved a conversion of an existing commercial structure, which then became a pharmacy, with associated conditions recommended by the design review board. Through this process, staff requested additional information from the applicant in order to make positive findings or relevant findings to the approval criteria through incompleteness letters and email communications, which are found in the exhibits. It's also important to note that the property has a current compliance action, County File V as in Victor 0038421. And that complaint includes issues related to installation of fencing, which blocks off vehicle access to fire controls, tents and other materials being used outside for storage. At the date of the creation of this PowerPoint, no additional information has been presented by the applicant appellant to support the request. The deadline for the decision per ORS is November 21st, 2024. As I mentioned previously, there's a current compliance action related to this case. The application was denied because of a lack of supporting evidence to demonstrate that the storage container meets ZDO 10502, which are the site and overall site and design standards, 10503, which are building standards, 10505, which are additional measures, and 07 and 08, which are regional design standards. A little bit about the property. We can see an image here. The property is located at the northwest corner of Southeast 82nd, Southeast Harmony. It's zoned regional center commercial, and its current use is a food depot, warehouse, grocery store, and a food cart pod. This is a copy of the applicant's submitted site plan. The dashed area towards the bottom right is the proposed storage container location and the existing loading dock space and berth. This is some reasoning for the denial. As mentioned previously, the applicant provided insufficient information in support of their request. There were no elevations, diagrams, or supporting narrative to demonstrate that the applicable approval criteria are met, and that's especially relevant to the development standards of ZDO 1000. The building and site criteria are not discussed, and the regional centers are also not discussed. My incomplete letter set forth requirements and additional information needed to make positive findings. Specifically, there was no information about walkway system or interconnectedness, no information about public entrance requirements for new commercial structures. There was no discussion or evidence about how a storage container can meet the general architectural characteristics that are required for the zone and for the development standards. Specifically, there was no commentary or plan shown on how it would meet roof design, glazing, material construction, and how it would meet public entrance requirements for new commercial structures. The additional standards are based on the area of the site, and there were no findings or information demonstrating how the site would comply with the additional measures. I will note that it's likely it could meet them through virtue of the fact that it went through previous design standard or design review approval, so it may be possible that they could be met. And essentially, this boils down to the reason staff and the planning director denied Z0075 included in Exhibit 1 because the application was not consistent with all the applicable criteria. Again, here is my contact information should the record be left open and additional information be submitted to the record. With that, I will conclude my presentation and I'm available for questions or comments.
Thank you, Mr. Porcel. My only comment is this a storage, wouldn't this qualify as a storage building, which is an allowed use in the RCC zone? I'm not sure that makes a whole lot of difference because the standards apply to buildings and it appears to be a building. But some of the standards apply to retail buildings, and I'm not sure that a storage building would.
Yeah, I think the use is fine, whether it's primary or accessory to what's
Okay.
already there. It's more
It's the design of the structure.
correct.
Okay.
Yep.
That was really my only question. Thank you, Mr. Porcel. Ms. Chong, I understand you're the applicant. It's your opportunity to present your appeal. And you'll need to unmute yourself, Ms. Chong. We're not hearing you yet.
Okay, hello.
There we go. Now we're hearing you. Thank you.
Okay, thank you. Yes, this is Virginia Chong, CHONG. I'm the applicant. I'm the owner of Food Depot, located at 12405 Southeast 82nd, Happy Valley, Oregon.
It's your opportunity to go ahead and present your appeal.
Well, on the appeal, I would say we actually didn't change anything. We just want to park a container, the regular container, commercial container, at the space of the loading dock, which is, it's already not used because it's too narrow. There's no way the big truck would park in there. So we don't change anything, won't block the traffic, anything, didn't change anything else. So that's the way I want to, just for extra space for our grocery. So that's the one I want to, apply a permit. We can park a commercial like the container. It won't bother anything, no extra bother the passengers or neighborhood, no causing any other traffic problem, nothing else. And on the same time, if we have a container coming, we just change to park the container on the other side of the building, which I show on the plan, and it's inside of the parking space. It's a building side, the left side of the building. It's not interfere that any will not occupy any parking space. Usually would be like we were getting every 2 months, just get a one container, maybe unloading an hour and a half, loaded and just left. So I don't think there's any interfere of the business or the traffic or neighborhood or our customer parking. So that's what I just want to appeal for.
I'm not clear where you would move the container when you get a delivery. Can you tell me again where you're going to put it, where you would put it temporarily?
Okay. Right, if we have a new container coming, the delivery coming, they will park at the left side of the building. We have enough space to have the truck pour inside of the property, which is inside of the gate. So
between the building and 80th Street?
Between the Harmer Road and inside the building, let me see. I didn't see the map, but I
I'm
already
looking at your site plan and
side plan. Okay, on the left side of the building.
Okay,
So the
left side as from where? Which direction are you facing when you say left?
Facing 82nd.
Okay, if you're facing 82nd, when you're back to the building, is that right?
On side of the building, the property, not the public street, not the Harmon Road. It's inside of the property.
I understand. I'm just trying to figure out what you mean by left side of the
Oh,
building.
okay. I'm
So if
sorry.
you're
If I,
standing in front of your building facing 82nd, that left.
yes,
So
yes, you're right. You're right.
what's that street? Sunnyside Drive
Yes.
to the north. Okay, so the north side of the
Oh,
building.
no, okay, you're right.
Okay, that I just wanted to make sure I understood where you were saying. Okay, I think the issue for staff is that storage container that you want to park there, for storage is considered a building under the county code, and therefore it's subject to these the design standards that are set out in the staff report that aren't met with the type of storage structure. I know it's a movable container, but it is a building also as defined by the code, so it is subject to those design standards. So
Okay,
that's the issue that's why staff denied this application.
I see. So what we need to do about the container, if we just want, if can be sitting a container of the building at the loading dock, because the loading dock is supposed to load the container will still can park, right, when we unload the stuff. It's just the time being it's movable, but just the park for a little longer time.
Well, it's essentially permanent, isn't
Oh,
it?
it's a permit. Oh, okay,
Yeah.
okay.
And because it's permanent, it's considered a building rather than a vehicle.
I see. Can we do some, decoration or something as a part of the building? So if will be, approved. I know it's not attached to building, but if they consider as a building parked as a permanent at a building, maybe do we paint it, look nicer? It's a container, okay. But
Yeah.
if we think about it, can we paint it just like the same color of the building as a part of building, look much nicer? Is that would be
Well, the
acceptable?
standards set out in the decision that the county issued, it has to, Mr. Forso can correct me if I'm wrong, but it has to have certain roof design requirements. It has to have access requirements. And there are other requirements that have to be met. It's not just the appearance. It's the shape and the look. It has to have an entrance. It has to have pedestrian access and other things.
Okay.
So that's the issue, and that's set out in detail in the staff decision that you appealed.
But I see. But it's a container, it's a container. It's not for the
I
public
understand that's what you
purposes.
want to do, but the code doesn't allow
I
you
know.
to just place a container permanently on that site.
I see. Okay.
It has to, if it's going to be there permanently, it is a building and therefore has to meet the building design standards,
Okay.
roof design, access, entrance, etc.
Okay. But I have a question. I saw some of the other, restaurants or other company, they hire or they rent a container parking their space. So is that meet the, requirements of the county? If the container is not ours, if we somebody rent the container from
It's not the
somebody.
ownership issue, I don't think, but I'll ask Mr. Forsell to respond to that.
Okay.
Yeah, so a couple of things.
Before we do, sorry, Mr. Forsell, there
Yeah.
was one attendee. I want to make sure everybody's had a chance to testify before we go to staff response. Ms. Kimberly Benton, you're the only person left. Do you want to testify? If so, please raise your hand to indicate that. And she's not raising her hand, so go ahead, Mr. Forsell.
Sorry about that. I didn't mean to jump in there
Oh, that's
too quickly.
okay.
So as you're probably aware, Mr. Hearings Officer, is that you can look around and find lots of things that may not be compliant with an example on one property. So I don't know. There could be other storage containers on other properties that don't meet the code. It's a tricky situation. So the storage container from our interpretation does meet the ZDO definition in 202 as a structure. And so it's placed permanently. Structures need to meet all of those design standards. And I understand the appellant's concern that they want to keep the storage container there for as a function of their business. But without meeting those design standards, I don't see how the application could be approved. There's probably ways to design it that could make it work, which I tried to suggest in my incomplete letter, but I don't think we got there. So that's essentially why we, at the county, denied the decision.
Thank you, Mr. Porcel. Ms. Chong, anything you want to add?
Yeah, like I would say, especially for this situation, the business is not really, we change a business type. So we do a lot of the to-go containers, like the to-go boxes and utensils. Those are the really space concern. So inside the building, it's not enough for these to storage these big boxes. So that's why we, have a container parked the outside as a storage. I can't, if they let me know if we can improve something or do something about that, I'd rather keep that, or how can we do to make it approved. Otherwise, I think it will hurt the business if we move that space, the container. I don't know, we have to hire other outside storage. It's also considered as, another expenses for the business and also the burden. That's what I think.
Okay. Based on what Mr. Porcel said in his incompleteness letter, it does set out some things you might be able to do to make it meet the standards. So you'd have to do provide some plans and narrative showing how you are going to meet those. That's the only way I could approve it. At this point, I have to agree with staff that it just doesn't meet all the design standards. I understand that you want to do that, but it has to meet the standards of the code in order to approve it.
Okay.
So what I could do is hold the record open to give you a chance to revise your application and address those issues that Mr. Porcel set out in his incompleteness letter.
Okay. Okay. I appreciate that.
In order to, Mr. Porcel, you mentioned ORS 11 on November 21st. Is that the 120-day clock?
Yeah, unfortunately, this kind of crept up a little bit, so we don't.
Ms. Chong can extend that for the open record. So, Ms. Chong, as I noted at the start, in order to, under state law, I'm required to apply to issue my final decision within 120 days after this application was complete, which in this case is next week, the 21st of November. But you can extend that if you want more time to revise your application. So I'm willing to hold the record open to give you the chance to do that if you're willing to extend the clock for that purpose.
Yes, I'm willing to.
And how long would you need to provide some revised design, some plans and narrative that address these criteria in the in Mr. Porcel's incompleteness letter?
Actually, personally, I don't really read that incomplete letters. I will check my the contractor, see how long it would take to address the issue.
And unless the county has any objection, I could hold it open for I'm trying to think how to do this because generally I hold it open for a specific period. But I understand you
I
want to
know.
talk to your contractor and figure out how long they're going to need to do that.
Yes, yes.
Um, I tell you what, if I hold it open for a month, and if you feel if you're after talking with your contractor, you need more time, we could give you that. I would be willing to extend it. Would that work for you? Or a month and a half, 2 months? I don't know how long you think that the contractor might need.
Maybe 2 months, it will be
Okay.
possible, I think. Uh-huh.
Okay. Mr. Forcell, any objection to that?
No, I think that's fine. I'm happy
Okay.
to try and make it work if it can.
Let me grab my calendar real quick. Yeah, if we can make it work, that's great. So that's what we're shooting for here. Today's the 14th of November, so 14th of December. Getting in the new calendar. 2 months would be January 14th, a Tuesday.
January 4th. Okay.
Um, Mr. Forcell would, if I assume you're gonna, obviously the county's gonna want the opportunity to review that and respond, and I will want them to do that. Would
Correct.
2 weeks be enough for you to do that? Her new submittal?
Yeah, I think that's fine.
Okay. So what I would do is hold it open until the 28th of January for the county to review and respond to your submittal, Ms. Chung, and the public if anybody's interested in this application, which so far nobody is. And then for an additional week until the 4th of February, Ms. Chung, for you to submit a final written argument without any new evidence. Because you as the applicant get the final word. If you disagree with the county, you can say so and why
Okay.
at that point. If you agree with the county, you can just say, we agree, and I'll close the record on the 28th. If after talking with your contractor, you need more time, you can submit to Mr. Forcell a request for a longer period and give me a specific date when you be able to submit it. And I will issue an order extending the open record.
Okay.
But I will need you, Ms. Chung, to expressly agree to, you'll need to waive the 120-day clock in this case in order to accommodate those open record periods. I can't give you legal advice, but what that means is right now, if I didn't make a decision by whatever date it was next week, and you didn't agree to extend the clock for that purpose, you could go to court and seek a mandamus action, which is an order from the court. Basically, it allows you to go to court to get an approval rather than through me. It's a more involved process. But that's what I'm asking is if you waive that 120-day clock, then we have much more time to make this decision. I have up to it won't take me long to get my decision out once the record's closed. It's mostly just to accommodate give you the opportunity to submit additional evidence.
Okay.
But you'll need to say that on the record that you're willing to waive the 120-day clock and also submit something in writing to that effect.
Okay. When would that be the day I should submit?
I'd like you to submit that by the end of the week. But can you get it by 5 o'clock tomorrow? Just an email to Mr. Forcell saying, I agree to waive the 120-day clock for this
Okay.
case. Wonderful.
Okay.
If I don't get that by 5 o'clock tomorrow, I'll have to make my decision based, I would have to deny based on basically affirm the director's decision. So I want to make sure it gets to Mr. Forcell. It shouldn't be an issue, but just wanted to let you know that it has to come in.
Okay. I will send an email or go to
That's fine.
just to talk to Mr. Forcell. Okay.
Okay, it has to be in writing, so email would be great. You can also, I recommend you talk to Mr. Forcell as well during this, or you or your contractor, to make sure you're meeting all the criteria that are set out in the decision. But hopefully you can make some changes and this can be approved. Just to check, Mr. Forcell, anything else from the county?
No, I think you nailed it. Definitely
Okay.
need that in writing though.
Yeah.
We're not open on Friday, so if you come
Oh,
in person, you'll want to do that by tomorrow at 4 p.m.
By tomorrow 4 p.m. in
I'm
person.
sorry that
Oh, I
today's
see.
yeah,
that's not
today's
right.
Thursday.
Yeah, I was like, that's not right. So
You
by
threw me off for
today,
a second.
yeah, by today, 4 p.m.
Okay.
And to reiterate, it would be good to talk with me during this period to discuss how you can address the criteria.
Okay. Ms. Chong, anything you want to add before I close the hearing? And
That's okay. I cannot make it today. I'm not in this area, but I would think I will send a
you don't have
written
to come in
email.
today. If you can send Mr. Forcell an email today
Email.
saying, I will waive the 120-day clock. That
Okay, I will
resolve
send
that
email.
issue. You can meet with him anytime during this open record period.
Got
And
it.
the sooner you do, the easier it'll be, you and or your contractor. But because he would be able to give you specific advice about what you might need to address.
Address to do. Okay, yes.
But
Thank
it's
you, sir.
the email waiving the 120-day clock has to be received by 4 o'clock today.
Today or tomorrow?
Today, because the county's not open tomorrow.
Oh, I see. I see. Okay. I see. Can I have Mr. Forcell's email address?
Yeah. Can you just put it back on the screen too so she could see it?
Yeah.
Thanks.
e4cell@clackamas.us.
Got it.
Can you see that, Miss Chong? You got
Yes,
it?
yes, I can see it. I will send you email before 4 today. Thank you so
Great.
much.
Great.
Thank you. With that, I'm going to close the hearing. I'm going to hold the record open for 2 months, as we just talked about. What did I say? Oh, January 14th of 2025 for Ms. Chong to submit a revised respond to the issues raised in the decision, demonstrating compliance with all the criteria. And until the 28th of January for anybody to respond. So the public could respond, but mostly for the county to respond and make findings about whether it does or doesn't meet the criteria. And then until the 4th of February for Ms. Chong to submit a final written argument without any new evidence. And again, you could waive that anytime after the 28th of January by just submitting an email saying we agree with the county. Or you can submit if you want to submit a final argument, you can submit it sooner. I will try and get my decision out within 2 weeks after that, which would be about February 18th. And as I noted, Ms. Chong, if you feel you need more time, submit something in writing to the county. They'll forward to me, and I will extend. If you waive the 120-day clock, we don't have any problem. So,
Okay.
so you just send an email to the county saying I need more time. Give me a specific date when you could get it into the county.
Okay.
Okay. So that
Okay.
concludes our hearing. Thank you. Oh, anything you submit has to be received by the county by 4 o'clock on the 14th of January or the 28th of January.
Okay.
Okay, thank you.
Thank you.
Conclude our hearing. Thank you. Have a good afternoon.